Hi everyone, I'm Rob Similcare in New York, and this is Guilt or Innocence. The two companies are as different as night and day, except for one detail: they're both called Apple. The company that manages the Beatles' interests, Apple Corp., sued Apple Computer shortly after its founding, citing copyright infringement. That lawsuit was finally settled in 1991 under the condition that the two companies not enter into each other's fields of business. Then came the iTunes Music Store and a fresh round of lawsuits. Joining us now with more is entertainment lawyer Jeff Liebenson, and from Mac Addict magazine, Nico Kukuvanis. Thank you both very much for joining us. Jeff, let's start with you. The lawsuit was basically ruled on today, and the judge said that Apple Computer Company was the winner, that it had not infringed this trademark. Tell us about that decision and what you make of it.
Well, that's right, Rob. It was a very high-profile case, and it really harkens back to that 1991 contract that you referred to. These two parties have been at war with each other literally for decades. They've had two prior lawsuits and two prior settlement agreements, and the key issue here is whether Apple Computer violated the 1991 agreement. And in that agreement, they had promised that they would not enter the Beatles' Apple Corps' field of use by engaging in activities in connection with musical content. That's what this case basically was all about.
And so the Beatles company, Apple Corp., sued. They say, hey, you're now in the music business, the iPod, iTunes, this is all very much music. But the judge said, well, they're kind of in music, but really they're only in the music in terms of the iTunes store. That's really what the Apple represents, and it's not getting into the quote-unquote music business. I mean, does that decision make sense to you?
Well, it does in some ways. Judge Mann, the judge in England, is apparently a very sophisticated, technologically savvy judge. He has an iPod. He's used iTunes himself, and he gave a very interesting analysis of it. But I think that ultimately the decision turns not on the technology as much as it does on common everyday words. The question in my mind is, what does in connection with musical content mean? And Apple was basically saying that they don't own content, they are not a record label, they don't own the copyrights, they're merely a music distributor, somewhat similar in the physical world to a record store, where they provide the location where the music can be bought. What the judge said was, in connection with musical content does not mean that, and that Apple Computer wouldn't violate unless they were acting like a record label.
Got it. There is a difference, of course, between an actual record label, which the Beatles company is, and what Apple's doing, which is basically a form of technology. Nico, let's bring you in on this. What have you been following this dispute for a while? You obviously follow the Apple Computer Company pretty closely. How big a win is this for Steve Jobs and Apple Computer Corp?
Well, I thought it was kind of a non-issue in the first place. I mean, Beatle Corp doesn't sell any kind of hardware, and Apple doesn't produce any music. It seemed pretty obvious to me, and kind of a waste of time, really.
I mean, obviously, the two parties involved didn't think so. Part of this might have been, of course, the Beatles trying to get some money out of this. I mean, they did get a settlement of $25 million the last time they fought this out and got this agreement.
Right.
And the iPod is about
so
the hottest
they're coming
selling.
back to the well, huh?
Yeah, well, potentially. I mean, the iPod is about as hot as it gets as far as consumer technology is concerned. Apple's stock price actually went up a little bit on this news today, didn't it?
Oh, I didn't notice, but yeah, I wouldn't be surprised.
Yeah, I mean,
this has been on the mind of a lot of other people, just because I don't really care.
I mean, what do you think about the relationship between Apple and the Beatles going forward? You know, as Steve Jobs has said a bunch of times, he wants to get the Beatles onto iTunes and onto iPods everywhere. The Beatles have been totally resistant to that. Do you think now this dispute is settled, there's a chance they might be able to get to the table together?
I wouldn't be surprised, but once again, I mean, all the Beatles fans probably already have all the albums or CDs or whatever by now, right? And if you buy new Beatles tunes now, you're just paying Michael Jackson, so I don't see the huge draw either way.
I thought Michael Jackson sold that. Didn't he have to sell that Beatles collection to pay off some of his legal debt? I thought he was selling some of it anyway, but now that he's in Bahrain, it's tough to keep track. Well, Jeff, back to you on this. I mean, where do you think this goes from here? Is this the end of this? I mean, the judge has made a settlement, made a ruling, is this going anywhere? Is this going to get these two parties to the table to potentially broaden their relationship and maybe get some of these Beatle tracks onto iTunes and iPods?
I'm sure ultimately there's going to be a resolution of this one way or the other. The Beatles are going to want to be able to sell their products to their fans. iTunes obviously is very interested in making Beatles recordings available. To refer back to the earlier comment, there's the compositions which are controlled by the music publisher, and Michael Jackson was involved in that, but there's also the sound recording rights, and that's Capitol Records here in America, EMI abroad, and the Beatles. So, you know, there's a lot of money at stake, and this battle really goes beyond just whether the Beatles' music is digitally distributed on iTunes or not. It's really a battle for control of the future, because this field of use issue between the two different Apple companies is really controlling, given iTunes' dominance in the market, who is going to be able to use that logo, in what sphere of use, and it goes way beyond where digital music is today. It goes to where digital music will be tomorrow.
I mean, Jeff, the issue in trademark law generally is there going to be confusion, right? I mean, are people out there in the world going to be confused because they're both using the same name and the same logo? And it seems kind of hard to imagine that, given the iPod's extremely well-known what it is, and iTunes, I mean, people know what that is, and they know pretty clearly what the Beatles and their music is. So was there really any risk of confusion between these two things, and is that why the Beatles lost this lawsuit?
Well, I think you make a very good point about confusion. Usually trademark law is about whether there's a likelihood of confusion. But in this case, the parties had prior litigations. There's a long history, and they had a voluntary contract, a settlement agreement between them where they agreed where there would be confusion and where there wouldn't be. And in that agreement, that's where they agreed that Apple Computer would not engage in anything in connection with musical content. So this really wasn't the general application of trademark law. It was a case of contractual interpretation based on what these parties meant in 1991. At bottom, what we're really talking about is something that is a long time ago. It's an eternity ago in terms of the quick escalation and development of digital entertainment. And what they meant in 1991, I'm sure, it's our tough job to interpret it now, but they couldn't have known in 1991 how this would all play out.
All right, Jeff and Nico, thank you both very much.